Good evening, everyone, and welcome to tonight's seminar on university governance, academic freedom, and freedom of speech. My name's Scott Stephenson. I'm an associate professor at Melbourne Law School. I'd like to begin by acknowledging the traditional owners of the land on which Melbourne Law School is located, the Wurundjeri people of the Kulin Nation, and pay respects to their elders past and present. I'd like to also extend that respect to all Aboriginal and Torres Strait Islander peoples joining us this evening. The way universities are structured and operated, as well as the extent to which they tolerate different forms of speech, are evergreen topics for those of us who work and study at universities. But recently, these issues have been front page news. In Australia, the remuneration of vice chancellors and the prospect of caps on international students have been the subject of considerable attention in Commonwealth Parliament and in the media. And then globally, the encampments on campuses and the debate about what is occurring in Gaza have challenged universities on the issue of freedom of speech, sometimes with dramatic implications, as the recent resignations of university presidents in the United States show us. So tonight's seminar on these topics could not be more timely. We're very, very fortunate to be joined this evening by three experts on the subjects of university governance, academic freedom, and freedom of speech. In the interest of time, I will provide us with just the briefest of introductions of our panelists. If you'd like to find out more about their biographies, there's a slightly longer version in the email advertising tonight's event. And of course, you can find more on their faculty web pages. So tonight we will hear from three panelists. The first is Will Partlett, who is an associate professor and one of the directors of the Centre of Comparative Constitutional Studies at Melbourne Law School. And he is the author of a forthcoming book, Why the Russian Constitution Matters, The Constitutional Dark Arts. Second, we will hear from Adrienne Stone, who is a Melbourne laureate professor and the other director of the Centre for Comparative Constitutional Studies at Melbourne Law School, and is the co-author of a recent book, Open Minds, Academic Freedom and Freedom of Speech. Then finally, we will hear from David Rabban, who's the Dar Jamal, Randall Ha Jamal, and Robert Lee Jamal Regents Chair in Law at the University of Texas Austin School of Law, and author of the recent book, Academic Freedom from Professional Norm to First Amendment Right. We will have time at the end of tonight's seminar for questions and answers by our panelists. So if you would like to ask a question at any point during the seminar, you can open up the Q&A panel that should be at the bottom of your Zoom screen, and you can type in your question, and I will do my best to collate and ask as many questions as possible of our panelists at the end. So without any further introduction from me, I'll hand it over to our first speaker, Will Partlett.
Thanks, Scott. So what I want to talk about in the next 15 minutes really is to think about what the constitution of the university is. And that's really a question that is engaging with the ideas and concepts from constitutional law and what they tell us about how power is structured within the university. And what I'm going to argue today, and in some of this work that I've been doing, is to say that actually constitutional law and its concepts, some of the key concepts that come from constitutional law, expose a series of questions that face university governance today, and that I think can potentially help us understand and better govern our these key institutions within our polities, these universities. So I guess at first it doesn't really seem a particularly good fit that why would we think constitutional law would be a good understanding for, or help us understand how universities function? We think constitutional law is often involving judicial enforcement of rights, and involves interpretation, and involves the role of the state and limiting the power of the state. It would seem in this context that corporate law would be the ideal way to understand, Corporations law would be the ideal way to understand the university. But there are at least two key similarities that I think mean that constitutional law and its concepts, and some of its key concepts, can help us understand the university. First, The university, like the state, is an artificial legal entity with office holders that exercise power on behalf of that artificial entity. As we can see in the University of Melbourne Act, Section 6 calls the University of Melbourne a body corporate with perpetual succession. It goes on to say that the office holders themselves, later in the statute, exercise the power to engage into contracts, to sue and be sued, right? So we have a corporate entity, much like a state is a corporate entity with office holders. At the same time, we also have, with respect to universities, they are also artificial entities with distinct goals and purposes, like the state, right? We think of the modern state as exercising legitimate exercise of power for particular goals, perhaps to protect freedom, to protect the common good, to advance economic growth, whatever. Similar with universities, they have stated goals. And we incorporate into universities for distinct global purposes and goals. So again, the University of Melbourne, there are 9 purposes. Their universities are, in many cases, quite complex institutional arrangements to provide and maintain teaching and learning environment of an excellent quality and undertake scholarship, or just a few of them that we see in the University of Melbourne Act. Right, so I think those are 2 ways in which I think we can see that the institution or the concepts of constitutional law are helpful in helping us to understand, I think, the way that the university operates. And I'm going to really talk about 3 distinct lines of constitutional scholarship that I think help to unpack or uncover some of the key ways in which universities operate. First, I think constitutional law helps us understand where is power and how is power exercised and really regulated in the university context, i.e., what is the constitution of the university? Now, for a long time, constitutional law scholars have been debating and talking about what they call the unwritten or invisible constitution, right? This is the constitution beyond the founding text. These are court decisions, legislation, established practices, or conventions. And what constitutional lawyers have found in that is that the less detailed the founding constitutional text, the more flexible a constitutional order will be, and the more self-regulating it will be. And that these types of kind of what many call unwritten constitutional orders, the classic examples being the United Kingdom and New Zealand, can be subject to informal exercises of power to some extent, and are sometimes subject to abuse of power without kind of rule or regulation. So we can think of potential threats to the way in which these unwritten constitutional orders develop, because they are so flexible. Now, I think that this insight and the understanding that we have of the unwritten constitution and potentially the way in which it can change very quickly is actually quite important for understanding the university. Right? If we look at the founding documents of most universities, wherever they may be, they're often very, very short, often very, very old, and often very, very don't tell us much. And that's even the case here in Australia. The University of Melbourne Act is 2009, but it really doesn't tell us much about the relationship, for instance, between the Chancellery and the faculties. It doesn't tell us a great deal of information about the real governing relationship. So in many ways, what we have in the university context is what a constitutional lawyer would see as an unwritten, flexible constitutional system. Now, that has certain advantages, but it can have certain problems. And trying to understand how to make that visible, I think, is a really important project in doing this. And so some of my work is then beginning the process of trying to render visible the invisible constitution of the university. And that's going to start with the charter or the founding statute or the founding document, whatever created the corporate entity. In many cases, for instance, in American universities, those can be 400 years old. In the UK or with Oxford, they can be almost 1,000 years old, right? These can be very old, very vague documents, but where do we turn after that? We must look to university regulations, university statutes, policies, bylaws, guidelines. How do they fit together? A lot of these types of questions remain somewhat unexplored. And I think part of the project that I'm beginning in, and I think what constitutional law can do is provide the tools to start to answer those questions, so that we can understand how and render visible the institution, visible the constitution of the university. And as part of that is to understand the role of in the American context, what's called the Office of the President, or in the UK or Australian context, the Office of the Vice Chancellor. This institution has changed radically in recent decades. To what extent? How do they interact with the rest of the institution? How do they interact with the faculties? How do they interact with academic self-governance, whether it be a Senate or an academic board? These are important questions, and I'm not going to today answer any of the answers to it. As this project is really just starting to answer that, but I think is starting to figure out where we can find the answers to that question. I think is a really important project, and then kind of rendering visible, in many cases, what are power relationships that are not often that visible, or that can be hard to find, and that are changing rapidly as universities are buffeted by by the influences of government, by influences of large amounts of money, from whether it's donations, whether it's money flows coming from international students, and so forth. We see that both public and private institutions, the constitutions, the way in which power is exercised, is being shaped constantly, and in some cases, as Scott was suggesting in the beginning, in important ways that we need to really understand. So that's the first kind of question that I think constitutional law can help us kind of get some purchase on. The second is to think about the relationship between, in particular, the central executive management team and the faculties, whether it's chancellor, as I said, or the presidency, and in the center, and the faculties on what we might call the periphery, right? And constitutional law has long recognized that the relationship between what we call the center and the periphery, in what is called federalism, is actually a really important, carries important values and important benefits. And that federalism, it actually tries to balance the relationship between the center and the locality or the periphery, in important ways, in this idea that diverse political communities, when they come together into a broader polity or legal entity, retain some of their own powers while they are at the same time incorporating into a broader one. And we can think of at least two ways in which that's the benefits that come with that. More effective governance is often governance that is closer to its to the local level, to the local authority. More superior knowledge about how this particular subunit operates. It can also lead to better trust and greater participation in policymaking. And in both cases, I think those can be important to understanding governance within the university. As I said before, at the moment, we have a trend across the UK, United States, and Australia towards centralization of power in the university, in the office of the president or the vice chancellor. And the questions are there benefits to balancing that decentralization with some levels of self-governance for the faculties themselves, who might, in certain cases, have better understandings of how their particular faculties operate, and so forth, and getting that kind of balance. And thinking about that balance is, I think, an important question that constitutional law surfaces, in particular, and also thinking about how we can increase trust, right? As we see in many incredibly centralized systems, trust often breaks down as power shifts to the center. So it can be important to increasing trust in these faculties, and increasing trust from also students in seeing and allowing a little bit more of a balance between self-governance in the localities and the faculties, and balancing that with what sometimes needs to be important coordinating power in the office of the vice chancellor or the president. And then the final question that I think I'll say just a few words on, and then I'm going to turn over to David and Adrienne on this, is to say constitutional law also helps us understand what structures are present to protect academic freedom and the freedom of speech. For a long time, constitutional law, for almost thousands of years, constitutional lawyers and thinkers have thought about structure as being critical, the relationship between institutions as being critical to protecting freedom. Now, that goes all the way back to the idea of the mixed constitution we had in the old Roman Republic, all the way through to the founding of the American order and so forth, and that it allows contestation and deliberation, participation in the protection of freedom. Now, in the university context, it does raise the question, how do we protect academic freedom? What structures are in place? How do we think about the structures of the university in actually allowing individuals to bring and to contest decisions potentially that that undermine the freedom, whether it's academic freedom by university academics or the freedom of speech by students? How do we see these types of decisions being made? What bodies and structures are involved in that process? And really kind of starting to surface this. And this is something that has come up obviously recently. We've seen this at the University of Columbia with some of the decision-making disciplinary processes that the University of Columbia has taken with respect to its own students in protesting the war and the conflict in Gaza. There have been questions raised about which institutions are being used by the Office of the President. And similarly, we see questions arising in the Australian context around not just definitions of academic freedom and freedom of speech, but where can these institutions and these definitions be protected, and how can they best be protected in ensuring that we have a more robust set of freedom of speech, and to really take us back to this central question that I started this with, which is, if we think about the university as an artificial legal entity that is formed as a group of, whether it's staff, academics, professional staff, and others to carry out certain purposes, one of those key purposes, of course, is to ensure the ability of individuals to speak freely. We need to begin to think about how those structures are created. And begin to think about, perhaps in that way, thinking about the university as a constitutional entity where power is exercised, and therefore thinking structurally about the university. I'll stop there. Happy to answer any questions on this in the Q&A. Thanks, Scott.
Wonderful. Thanks so much, Will, for getting us off to such a really interesting start. So now I'll hand it over to Adrienne.
Thanks very much. So I came to my interest in academic freedom via my interest in public law, specifically through my interest in freedom of expression, and that I think is a common pathway. But the more I've thought about academic freedom, I have found that thinking constitutionally about the university gives some interesting structure to my thoughts, and I want to identify what I think are at least 4 insights that arise from taking a constitutional mindset towards universities and questions of academic freedom. Now, of the first of those 4 insights is Will Partlett's insight. That is that the way that structures and power operates within the university is critical to the capacity of universities to fulfill their research and teaching mission. I won't say anything more on that. I want to identify 3 other implications. One is, I think, thinking constitutionally about the universities allows us to see distinct institutional roles that the university performs within our polity. And secondly, and from this, I think we get a better understanding of the nature of the core values of academic freedom and freedom of speech. And lastly, I want to suggest that I think it points us to the necessity that we pay attention to the way in which norms of academic freedom are internalized within the institution, and specifically within all individuals in the institution. So let me start with an institutional perspective on universities. It's a central interest of public lawyers is to think about how institutions operate within a polity and the relationship between them. So constitutional thinking is long focused on this. And I want to suggest that thinking constitutionally points us to 2 distinct institutional roles of the university. One way is to see the university as an institution of civil society, and another way is to see it as an accountability institution. So let me start with the relationship between universities and civil society. So there is a constitutional conception of the institutions of civil society that focuses on the way in which institutions of civil society are important for allowing citizens to come together and pursue their own interests. To that extent, civil society is important because it keeps, to some extent, the state at bay. But civil society institutions are also important because they allow some disciplining and holding to account of government. So we are very familiar in the way in which civil society institutions do that. And for this reason, I think they can be seen as essential for maintaining the democratic society character of a society. Now, for some, the characterization of a university as an institution of civil society is not easily applied, at least to public institutions. Now, I actually think the distinction between a public university and an institution of civil society is much less clear than this traditional line of thinking. But allow me just to put that aside to say that even in their public guise, universities are important because of the way in which, if they're not themselves institutions of civil society, they at least amplify the activities of civil society. So in very many ways, universities are forums in which we see cultural, sporting, social, and political activities that might occur off campus, but which for university is a key forum and which gives people a voice. And so insofar as civil society institutions are important for holding governments to account, allowing citizens to come together to form a conception of their own purposes, I think universities are important institutions. In addition, universities have a distinct role in the way in which they pursue and disseminate knowledge through teaching and research. A foundation for this view is an understanding that knowledge is essential for government and especially for democratic government. When we have knowledge, we are able to promote accountability, and through it, governmental legitimacy by enabling us to determine as citizens, for example, if our rights are being respected or if government is abusing power. It is necessary in a technical sense for sound governmental decisions. It's also really important for the public understanding of governments. So having institutions like universities that pursue knowledge provides a focal point for collective action, helps us nurture the way in which we pursue knowledge, applying appropriate standards and cultures of independent thinking. And it's really vital to maintaining the integrity of democratic government. Now, in this sense, universities can be understood to be a kind of constitutional institution. The US scholar Vicky Jackson has identified them as knowledge institutions. And knowledge institutions bear some relationship to what in constitutional law we tend to think of as fourth branch institutions. That is the branch that oversees the other branches of government and exists to ensure their integrity and act as guarantors of democracy. So universities can be understood as institutions of civil society and at the same time as knowledge institutions, which through their distinct role of pursuing and disseminating knowledge, promote accountability of government. If we are to take this view of universities as knowledge institutions, we should also see that universities pursue knowledge in distinctive ways. There are other knowledge institutions in society. We can think of, and Vicky Jackson would suggest, for example, that we would consider some government offices like the Bureau of Meteorology or the Bureau of Statistics to be knowledge institutions, for instance, but universities are important because they bring a unique combination of expertise developed through research training, which, for example, distinguishes universities from another important knowledge institution, the press. We pursue it through expertise. We pursue it in ways that are disciplined by the standards of methods of academic research disciplines, which insist on among other things, on evidence and justification, which expose ideas systematically to tests capable of invalidation, and as part of parcel of them, require independence. So universities are knowledge institutions, and they are knowledge institutions of a special kind. So what follows then, and this is my third point, from understanding universities to have this dual role as civil society institutions and knowledge institutions? Well, first of all, it helps us see the distinction between academic freedom and freedom of speech, two core university values which are often run together. Our commitment as in universities to freedom of speech reflects the status of universities as civil society institutions. It's a right that we hold as citizens. It serves values related to the individual's own interests, such as their dignity and their autonomy, as well as institutional interests, for example, by promoting democratic government. But academic freedom is quite different in a sense. It arises from the status of the university as a knowledge institution. It serves the pursuit of knowledge through teaching and research, and it's not best conceived as a right of the individual. Academic freedom has limits that reflect its purpose. It's a freedom to engage in research and teachings in accordance with the academic disciplines. It encompasses a right of public engagement, but it is in the support of the pursuit of knowledge, and it is therefore limited to matters in relation to which academics have some plausible expertise. And lastly, it does support criticism of the university, a traditional element of academic freedom, but it does that because allowing academics to criticise university government is part of ensuring that university government is infused with academic judgment. So once we understand academic freedom and freedom of speech as being distinct values arising from different institutional roles of the university, then we can begin to understand them better. We will have a better understanding of the conditions for effective operation of a knowledge institution. So the primacy of academic freedom directs us to understand that the university owes its researchers and teachers academic freedom, including rights of public engagement and criticism of academic government, and that the university itself is owed institutional independence, not for its own right, but so that it can provide a forum in which knowledge can be pursued freely, independently, and in accordance with academic disciplines. I think also that once we understand these two values as arising from distinct institutional roles, we can begin to understand the relationship between them. And here's a very short statement of views I've developed at length elsewhere, that although we understand academic freedom as more limited than freedom of speech, and I have explained some ways in which I think it is more limited, it is also the predominant concern of universities, that its role as a knowledge institution is distinctive to the university. Its role as a civil society institution is shared with other institutions. And so that is the one that I think universities have the obligation to protect most fiercely. And there may be cases, rarely though, but sometimes, of conflict between academic freedom values and free speech values, in which case my own view is that the academic freedom values prevail because the university is a special place for the pursuit of knowledge, and that ought not to be jeopardised by allowing the politics of the society at large to be exercised on its campuses. My final point is this. If we think about universities in the way public lawyers think about constitutions, we will also see that scholars are themselves constitutional actors. So if we take Vicky Jackson's claim that universities are knowledge institutions seriously, we can see that all of us, all of the time, in doing our scholarly work, are doing work that promotes democratic government. Now, just to speak to my own subfield of constitutional law for a moment, there is some suggestion in the literature that constitutional scholars have a special status as constitutional actors. But in my view, that is contingent. Sometimes our work as constitutional scholars will be particularly significant for the accountability role of universities, but there will be other times where other disciplines might come to the fore, and there is democratic value in all of our work. So that's the first understanding that I think comes out. Scholars are constitutional actors. And constitutional law teaches us that an internalized sense of norms by individual constitutional actors is important, in addition to institutional structures. So no matter how clear your constitutional text is, how powerful your constitutional institutions are meant to be, the proper operation of a constitution is dependent on individuals acting consistently with internalized norms, at least most of the time. So the protection of academic freedom depends on many small decisions made day to day throughout the university. And it's therefore important that academic freedom values are properly understood throughout the university. So, for instance, those members of academic staff, of professional staff who deal with the way academics are employed and the conditions of governing their employment need to understand that these may be adjusted to reflect academic freedom values. But equally, academics and scholars need to understand that the best justification for their special freedoms arises from the exercise of expertise and independence, and they ought therefore to act in ways that do not threaten it. They should carefully consider the limits of their expertise in the way they engage, for example, in public commentary. And if they choose activism to be part of their academic life, a choice that I think is valid and in fact to be applauded, they ought carefully consider that the way that they conduct their activism is permissible and does not contradict their core obligations to pursue knowledge through teaching and research. I look forward to hearing from you in the discussion. Thanks.
Wonderful. Thanks so much, Adrienne, for continuing the conversation. And then finally, we have David.
Thank you. So in my comments, I will discuss the constitutional status of institutional academic freedom in the United States and address its application to the organization of power in a university and to the role of a university in a democratic society. The constitutions of some other countries, though we see not all, refer explicitly to academic freedom. The US Constitution does not. The Supreme Court first recognized academic freedom as a right under the First Amendment of the Constitution in 1957, differentiating it from political expression. Initially identified as a right of professors, beginning in the late 1970s, the Supreme Court extended the First Amendment protection of academic freedom to universities as institutions. The Supreme Court initially applied institutional academic freedom to university decisions about affirmative action in the admission of students. And many other cases have applied it to uphold decisions about student dismissal, curriculum, and the appointment and tenure of faculty. In my opinion, the validity of an institutional claim to academic freedom should depend on who makes that decision on behalf of the university, although judges have not addressed this issue in deciding cases. There's a 1966 statement on government in the United States, which is jointly formulated by organizations of professors, administrators, and trustees. And this statement, I think, helpfully addresses the distribution of authority within the university. The faculty, it declares, and I'll quote from it now, has primary responsibility for such fundamental areas as curriculum, subject matter and methods of instruction, research, faculty status, and those aspects of student life which relate to the educational process, end quote. The statement bases this primary responsibility on what it calls the fact that faculty judgment is central to educational policy. And it asserts that scholars in a particular field or activity have the chief competence for judging the work of their colleagues. It also recognizes the more general competence of experienced faculty personnel committees having a broader charge. Now, while maintaining that the administration and the governing board should concur with the faculty judgment in areas of primary faculty responsibility, the 1966 statement recognizes that administrators and trustees have the power to reverse faculty decisions in exceptional circumstances for compelling reasons. Such reversals would be a legitimate exercise of institutional academic freedom. The 1966 statement does not specify what constitutes exceptional circumstances or compelling reasons, but they are generally understood to include convincing evidence that the faculty did not exercise or deviated from academic standards in making decisions. Although it acknowledges primary faculty responsibility for many academic decisions by a university, subject to administrative and board review, the 1966 statement identifies a greater role for governing boards and administrators regarding some academic matters. For example, it views the development of what it calls general educational policy as a joint effort among all three groups. And I think the reasoning of the 1966 statement helps identify specific examples of educational decisions within the proper locus of the governing board and the administration. A university may have an institutional commitment to a classical education or to experiential learning. A university may decide to become coeducational, as many American universities did in the late 1960s and early 1970s, or to remain single-sex, as have several women's colleges in the United States. Universities place various emphasis on the mix of scholarship, teaching, and service expected of faculty. They may have educational reasons for adopting policies on affirmative action, enacting a code governing speech on campus, regulating student extracurricular activities, and restricting access to the campus by the general public. Universities make financial decisions with clear educational implications, such as giving more money to an emerging field or less money to fields with long-term declines in enrollment. I think, and I think it's consistent with the 1966 statement, for administrators and governing boards to make these decisions, though, as the 1966 statement provides, faculty advice about them is useful and should be sought. The enforcement of policies against sexual harassment and external funding of faculty research has raised issues recently about the distribution of power in a university. Current interpretations of sexual harassment under federal law covers speech that creates a quote-unquote hostile environment. A report of the American Association of University Professors, the AAUP, included examples of administrators at various campuses assigned to enforce this law who have sat in on classes unannounced, challenged a professor's pedagogy, urged that professors issue so-called trigger warnings about especially sensitive or disturbing curricular content that might harm students who have suffered past trauma, and investigated a professor based on an article she wrote entitled, quote, "Sexual Paranoia Strikes Academia." The report observed that these administrators often lack faculty standing, work in human resources departments or offices of equity and inclusion, and are insulated from professors and from systems of shared governance within universities. As a result, the report stressed, the administrators have not considered potential concerns about academic freedom. It urged faculty participation in the creation and implementation of policies that define prescribed conduct and speech while protecting academic freedom and free expression, and that incorporate peer review. The AUP has also issued recommended principles about the regulation of external funding. Universities should prohibit faculty from accepting money from external sources who ghostwrite articles for professors to sign and publish under their own names. All of this, by the way, has happened in the United States, what I'm about to describe. Nor should universities allow professors to receive money conditioned on the right of external funders to alter the design of a research project after the initial agreement has been signed, to revise the resulting article, insert their own statistical analysis, or require professors to obtain permission before disseminating their research at professional meetings or elsewhere. University regulations prohibiting these conditions on faculty research, like those prohibiting plagiarism or falsification of data, do not violate the individual academic freedom of professors. They rather identify unprofessional behavior by professors that is inconsistent with the exercise of academic freedom in research and publication. To protect against possible abuse, universities should also be able to require that professors disclose the sources of their outside funding research. It is also legitimate for universities to restrict external funding of research that must remain confidential or classified. These restrictions again serve the purposes of academic freedom, fostering the discussion of ideas and the dissemination of knowledge. Professors who accept conditions on research that prevent open inquiry and publication undermine rather than exercise academic freedom. So in closing, I'll turn briefly to the relationship between institutional academic freedom and the role of the university as an institution of democratic government. American scholars and judges have stressed that professors teach students how to think critically and how to discuss their ideas with others who disagree. Intellectual skills that prepare students for citizenship and leadership in a democracy. In a phrase that has been repeatedly cited, a Supreme Court justice referred to teachers as, quote unquote, the priests of our democracy, whose special task is to foster those habits of open-mindedness and critical inquiry, which alone make for responsible citizens. The 1957 decision that first recognized academic freedom as a First Amendment right emphasized the grave harm resulting from government intrusion into the intellectual life of the university and asserted the dependence of a free society on free universities. Now, I find these assertions of the relationship between university teaching and democratic citizenship theoretically convincing, but I'm not convinced that people who are college graduates are better democratic citizens and leaders than those who are not. I do not see substantial evidence of their superiority in public life. The American journalist David Halberstam convincingly used the term, quote unquote, the best and the brightest, ironically, while demonstrating how extremely well-educated Americans, often reflecting an arrogance that might have been fostered in part by their elite college educations, made terrible decisions about American policy in Vietnam that led to substantial loss of human life and undermined democracy at home and abroad. I doubt higher education typically produces worse citizens, but I also doubt whether it typically produces better ones, even though I agree that the intellectual attributes of critical thinking and toleration of dissent contribute to a democratic society. Perhaps the benefits of learning these intellectual skills is often offset by the reinforcement of an elitism and sense of entitlement that undermines democratic values. And I think that even if university teaching does enable students to become better citizens, the primary function of both scholarship and teaching is academic. The production and dissemination of knowledge often has pragmatic societal benefits as well. It can contribute to public health and safety and to the development of public policy. But I think these pragmatic benefits reinforce rather than underlie the fundamental justification for academic freedom. Knowledge itself is a great value to society, even when it does not produce additional benefits. So I'll stop here and look forward to hearing from you. Thank you.
Wonderful. Thanks so much, David, for bringing in that comparative perspective that really neatly rounds out the three presentations. So we're running out of time, so I think I might wrap it up here and just thank everyone for attending tonight and for your really interesting questions. I'm sorry we didn't get to all of them quite in all their detail, but please join me in thanking our three panelists for such a terrific and very informative discussion this evening, and thank you all for attending.